The Colonial Land Patent System in Maryland, Part 2.
Examiner General and Deputy Surveyors. The qualifications necessary to become the Surveyor General, Examiner General, or a Deputy Surveyor, and the duties associated with those offices, are not specifically listed in any reference. Mr. Kilty, after a long and thorough review of all the records in his possession, came to several conclusions. The Surveyor General was more like a chief steward than a practical surveyor of land. Accordingly, a Surveyor General seldom made surveys, although there are instances of his being desired or directed to do so. In the early years, he was always a member of the council. He appointed the deputy surveyors according to the terms and fees that he thought proper to stipulate, and were held responsible for their conduct. As time passed, the office of the Surveyor General was so devoid of public functions that no instructions had to be issued to those serving in the post. The deputy surveyors, as they were titled, were in effect county surveyors, and performed all of the work. After the appointment of the Examiner General, the Surveyor General does not appear to have ever seen the certificates returned by the deputies before a patent was issued. The situation finally came to the point where the deputy surveyors were directly appointed by the governor. The Examiner General was responsible for the supervision and conduct of the deputy surveyors. In addition, he concentrated on the various disjointed regulations and customary rules governing the forms of surveys and the privileges of the several kinds of warrants, and assured that the certificates were in every respect regular and perfect before they were admitted to patent. There is no existing record of exactly what criteria or test the certificates had to pass. Kilty presumes that the examiner was supposed to recompute the area contained in the plot, and then apparently scale the lines shown on the drawing to see if they agreed with the distances given on the certificate. He also determined whether the certificate conformed to the warrant and ascertained that stringing, as it was called, had not taken place. Stringing is the practice of connecting one area to another by a line when the two areas so connected did not in fact share any common boundaries. Kilty made some rather caustic remarks about the Surveyor General and the Examiner, which may add some insight to the situation. The reason that these two officers were ineffective was that the Surveyor General, whose position was to superintend and direct the deputies, did not see their work, and the Examiner, who had no such authority, never extended his attention beyond the particular certificate before him. 5 types of warrants. 5 different kinds of warrants were issued that had to be acted upon by the surveyors: common warrants, special warrants of vacant cultivation, warrants of resurvey, escheat warrant, and warrants on the proclamation. Common warrants only applied to vacant land that was waste, uncultivated, and new in every respect. Strictly speaking, they could not affect land which, though never cultivated or improved, had ever been regularly surveyed. Common warrants received no location in the office. They were located by the surveyor, and bound the land from the date of such location. Property location was contained in the body of special warrants, which therefore bound the land instantly. This required that the location given sufficiently describe the land intended in a manner not to be easily mistaken. Most of the examples that Kilty lists do not meet this requirement. Warrants of resurvey are held also to contain a binding location in the body of them in respect to the vacancy proposed to be added. This doctrine was subject to doubt, and was decided in various ways. After some debate, it was finally decided that warrants of resurvey bound all contiguous vacancies, but the holder of the warrant did not have to take all of the vacancies. Escheat warrants could only be issued for land which had previously been surveyed and patented, the land then having reverted to the proprietary. In England, reversion of the title to the land to the sovereign occurred if the owner was convicted of a felony or treason, or died without heirs. Baltimore's charter specifically provided that in such cases the title reverted to him, rather than the English crown. Most of the cases of escheat in the colony resulted from the owners abandoning their lands, or dying at an early age, without heirs. The person who first obtained this warrant had preference, for it contained a precise location in its body. Proclamation warrants only pertained to land which had been surveyed but not patented. In order to encourage people to apply for proclamation warrants, they also included the privileges of the warrant for resurvey, which usually allowed the applicant to pick up all vacant contiguous land. The amount of land specified in a common or special warrant could not be exceeded by the description furnished in the certificate of survey. If an error occurred, and it was due to the direction of the person to whom the warrant had been issued, the certificate would become void. If the error was the responsibility of the surveyor, he had to amend his certificate. This rule, however, later appears not to have been enforced. A 10% increase was usually allowed. However, if that was exceeded, an additional payment was required. Lack of enforcement of some of these restrictions was, of course, due to the fact that those in authority were without exception the ones who took the most land. The time for prosecuting the surveyor for neglect was limited to 6 months after the survey was completed.
The end of the province and the new state. The proprietary government continued to issue warrants until May 1777, although it would appear that the Declaration of Independence and dissolved the proprietary rights. Mr. Eden, the last governor, left at that time, but it was not until the 15th of May 1777, that Mr. Hartford, who had inherited the colony, handed over to Mr. Peel, the newly appointed register for the state, the land records. This included title to all the manors and reserves and the lands remaining vacant and ungranted in the newly erected state of Maryland. At the conclusion of the war, Mr. Hartford returned to the colony, and attempted to recover his lands. Failing in that, he attempted to have the rents assigned to him, which was also refused. He returned to England after about 2 years. Governor Eden, who returned to Maryland in the company of Mr. Hartford, perfected several patents by adding his signature. He did this as late as 1804, though the patents had been left unsigned in his secretary's office when he left in 1776. When his authority to do this was challenged, he gave a very candid explanation, stating that he had signed no patents except those which should have been before he withdrew from the government. He completed the patents because he considered them a debt due from him personally to the parties, and he disclaimed any notion that he had authority that or any other public act.
Instructions to surveyors. The date of the earliest instructions issued to surveyors is not known. The instructions that were issued in December 1778 referred to the fact that they were substantially the same as those already in force. The 1778 instructions consist of 23 sections plus oaths of office for the surveyor and his assistants. Until the recent abolition of county surveyor, these rules remained in effect, with only slight alterations. Rule 1 requires the surveyor to keep a book in which to note down the time a common warrant is presented to him, and if he feels it covers an area already surveyed, he is required to show his entry of the previous warrant to the person making application. Rule 2 contains the requirement that the beginning shall be described as well as full as the thing will admit of, and then only mention course and distance to the last course, which is always to be expressed thus, then with a straight line to the first beginning. Rule 6 requires that you are to make all surveys as regular and square as you possibly can, and by no means unite one bit or sot by a string, a line, and when it can be done you are always to make the line or lines of one tract the line or lines of another. That no small parcel or spots of vacant land shall be left out. The practice of resurvey by jury had fallen into disuse long before Kilty's time. Kilty gives an example of a case where a dispute was settled in this manner, quoting the original petition in full, and the resulting order of the court, which read: Ordered that a warrant of resurvey be issued for the said tract called Whitmarsh Delight to be laid are according to the true ancient intended metes and bounds thereof to be ascertained by a jury of the neighborhood, by the sheriff of said county of Somerset, thereunto lawfully impaneled and sworn for the survey's direction, given also power and command to the said sheriff to swear witnesses. This was issued in 1681 and signed by the Right Honorable Lord Proprietor. The jury, some of whom swore they were present when the original survey was made, gathered at the site. As a result of their inspection and deliberation, they asserted that the third line of the description was erroneously given as east, instead of west, and they all signed their names to a new certificate on the 29th day of March, 1681. Kilty remarks that the resurvey, under the directions of juries, must have been enormously expensive to the parties. Their verdicts or record afford abundant evidence of the incompetency of the people, usually summoned on those occasions to weigh and compare the testimonies offered. The right of the proprietor to dispose of land at his price, with reservations, rent, or other stipulations that he may have established, was never questioned. However, the necessity of depositing the records in public office brought the operation under limited government control. In 1771 there was a serious contest between Governor Eden and the lower house of the Assembly concerning the right of regulating the fees of the land office, either by proclamation or by law. It was brought out that if the proprietor had the power to order exorbitant fees, he may prevent landholders from ever inspecting the records and obtaining the transcripts in order to prove their titles, and by this manner people would become tenants at the word of the proprietor, and not own their land in fee simple. When Eden attempted to the Protestants that the government would operate with moderation and justice, the famous statement, somewhat indicative of the growing mood of rebellion, ran, "Who are a free people? Not those over whom government is reasonable and equitable exercise, but those who live under a government so constitutionally checked and controlled that proper provision is made against it being otherwise exercised." Kilty points out that this contest showed that the nature of the land office in Maryland was equivocal. Its rules were obscure, and it was therefore time that some definite references were made available to govern its operation. The archives of Maryland contain hundreds of letters from Governor Sharp to Lord Baltimore. Many of them have to do with land problems, and even more concern the dispute with the pens that was finally settled by the Mason-Dixon survey. One of the interesting letters, written in 1754, when Sharp had been asked by Baltimore to set up an additional manor, reads as follows: "There is no tract large enough except in Frederick County near the frontiers, and there are two there already, Carrollton and Concochiaquie. The method always followed here for locating land warrants, by selecting the most rich and fertile soil without regarding any regularity of its area, or making one of its courses coincide with the boundaries of the adjacent prior patented tract, has left the land remaining vacant, and uncultivated in such small and incommodious parcels, that it is thought scarcely worth anyone's while but those whose possessions join to take it up. Kilty's book is divided into two parts. We have considered only the first book, which brings the operation of the Land Office to the time of the Revolution. He summarizes the situation of that time in these words. It is hardly necessary to observe that the province was originally nothing but a great land market in which the institution of civil government, and the advancement of political and social objects were of necessity to be preceded by the increase in population, beginning with a handful of adventurers, that his increase depended primarily on the encouragement held out to the immigrants, and the mode and degree of that encouragement on the sole will of an individual.